Hello, and welcome to Part 4 of the HUD Office of Public and Indian Housing Training on Violence Against Women Reauthorization Act of 2013. Again, I'm Miranda Stern, and I continue to be joined by my colleague, Ryan Jones. In this part, we will discuss lease bifurcation, reasonable time to establish eligibility, termination of the victim due to actual and imminent threat, and establishing waiting list preferences. As a reminder, the material discussed in this training may be found in Notice PIH 2017-08, specifically Sections 16 through 19. Lease bifurcation is an optional method. PHAs or owners may choose to bifurcate a lease or remove a household member or unlawful occupant from a lease to evict, remove, terminate occupancy rights, or terminate assistance to such members who engage in criminal activity directly relating to domestic violence, dating violence, sexual assault, or stalking against an affiliated individual or other individual. Bifurcation must be consistent with a reasonable time to establish eligibility, which we will explore in the next slide. Eviction removal, termination of occupancy rights, or termination of assistance must be effected in accordance with procedures prescribed by federal, state, or local law for termination of leases. For example, some jurisdictions may prohibit partial or single-tenant evictions. Court-ordered eviction of the perpetrator pursuant to applicable laws results in the underlying lease becoming null and void once the PHA regains possession of the unit. The PHA or owner would then execute a new lease with the victim. HUD encourages PHAs and owners to simultaneously attempt to reach agreement to the mutual termination of the lease if it is safe to do so. Ryan, can you talk about lease bifurcation in the context of the HCV program?
Yes, thanks, Miranda. In instances where the owner allows for lease bifurcation as a remedy to an incident of domestic violence, dating violence, sexual assault, or stalking, the owner may, but is not required to, bifurcate the lease, which evicts or removes the perpetrator from the unit without evicting or removing the victim from the unit. If the owner does bifurcate the lease, the owner must immediately notify the PHA of the change in the lease and provide a copy of all such changes to the PHA. Except for PHA-owned units, the PHA is not a party to the lease and therefore cannot bifurcate a lease agreement between an owner and a tenant. It is up to the owner to bifurcate the family's lease to evict or remove the perpetrator from the unit. Bifurcating a lease and evicting certain family members may have consequences for both the owner and the family. For example, a change in family size and composition may impact the determination of the appropriate number of bedrooms and the amount of subsidy paid by the PHA to the owner. To the extent that the change would adversely impact the subsidy standard for the family, PHAs may grant an exception to its established subsidy standards if the PHA determines that the exception is justified by the age, sex, health, handicap, or relationship of family members or other personal circumstances. A PHA may adopt a policy to include an instance of domestic violence, dating violence, sexual assault, or stalking under other personal circumstances. A best practice in the event an owner will bifurcate the lease as a result of domestic violence, dating violence, sexual assault, or stalking is for the owner to refer the family to the PHA in advance of the bifurcation, as this may allow the PHA to offer assistance or otherwise provide service referrals to the victim in advance of the bifurcation. The VAWA final rule establishes a reasonable time to establish eligibility under the covered housing program or find alternative housing program following a lease bifurcation in situations where the individual who was evicted or whom assistance was terminated was the eligible tenant. This would only be an issue for mixed families where assistance is being provided to the perpetrator and the victim is a member of the household who hasn't contended eligible immigration status. If a PHA or owner exercises the option to bifurcate a lease and the individual who was evicted or for whom the assistance was terminated was the eligible tenant, the covered housing provider must provide to any remaining tenant or tenants that were not already eligible a period of 30 calendar days from the date of bifurcation of the lease to A, establish eligibility for the same covered housing program under which the eviction or termination tenant was the recipient of assistance at the time of bifurcation of the lease, establish eligibility under another covered housing program, or C, find alternative housing. The VAWA final rule allows for 90 days except where prohibited by statute. In the Housing Choice Voucher and Public Housing Program, the 90-day time period does not apply. In these two programs, assistance is limited to 30 days if the remaining family member has not submitted documentation evidencing a satisfactory immigration status or a pending appeal of a verification determination of the family's immigration status. This is because Section 214 of the Housing and Community Development Act of 1980 requires that assistance under these programs be terminated after 30 days if the remaining family members cannot indicate they have satisfactory immigration status. There are subtle differences in the Public Housing and Housing Choice Voucher program and how this works. Miranda, when may a PHA initiate eviction proceedings in public housing?
In public housing, the PHA must not initiate eviction procedures until 30 days after the lease bifurcation. Ryan, what about the Housing Choice Voucher Program?
In the Housing Choice Voucher Program, the PHA must not stop paying HAP until 30 days after the owner bifurcates the lease to evict the perpetrator. The PHA may pay HAP for the full month if the 30-day period will end mid-month. If the victim requests to move, the PHA should not issue a new voucher until eligibility has been determined. Within the Housing Choice Voucher Program, the victim and PHA do not have to wait for an owner to bifurcate the lease for the PHA to offer continued assistance for the unit, where the victim is planning to stay in the unit. While the family would not have to wait for bifurcation to occur, it would have to wait for eligibility to be determined if the victim was planning on moving with the assistance.
As we talked about in Part 1, the VAWA final rule prohibits denial of admission or assistance, termination from participation, or eviction on the basis of or as a direct result of the fact that a tenant or applicant is or has been a victim of domestic violence, dating violence, sexual assault, or stalking. However, to clarify further, the rule does not prohibit the PHA or owner from terminating assistance or evicting a tenant if the PHA or owner can demonstrate an actual and imminent threat to other tenants or those employed or providing services to the property. In order to demonstrate an imminent and actual threat to other tenants or employees at the property, the PHA must have objective evidence of words, gestures, actions, or other indicators that meet the standards in the following definition. Actual and imminent threat refers to a physical danger that is real, would occur within an immediate time frame, and could result in death or serious bodily harm. In determining whether an individual would pose an actual and imminent threat, the factors to be considered include the duration of the risk, the nature and severity of the potential harm, the likelihood the potential harm will occur, and the length of time before the potential harm would occur. Eviction or termination of assistance should only be used when there are no other actions or remedies to reduce or eliminate the threat. This is the case even when time periods are more immediate. Further, HUD encourages PHAs and owners to work with local law enforcement to prevent or remedy instances where a threat may occur. We will discuss on the following slide some actions that may be taken to reduce or eliminate an actual and imminent threat. A PHA may consider the following actions: barring the perpetrator from the property, changing the victim's locks, installing basic security features such as better lighting or an alarm, encouraging the victim to seek an emergency transfer, allowing an early lease termination, allowing the victim temporary absence from the assistant unit, helping the victim access available services and support, such as providing information for a local victim service provider and civil legal assistance providers to help the victim get any necessary court orders, and working with police and victim service providers to develop a safety plan for the property and victim. Now we look to Ryan, who will go into detail on establishing a waiting list.
Thank you. The VAWA final rule clarifies that the PHAs may establish preference for victims of domestic violence, sexual assault, and stalking in addition to domestic violence. PHAs should consider whether to adopt a local preference for admission of families that include victims of domestic violence, dating violence, sexual assault, or stalking. Keeping in mind that a PHA system of local preferences must be based on local housing needs and priorities by using generally accepted data sources and information obtained through the PHA plan public comment process. HUD encourages PHAs to work collaboratively with healthcare providers, social service providers, homeless service providers, continuums of care, and local offices of government and community organizations to establish a system of preferences based on local housing needs collectively identified by the community. HUD recommends that a PHA's local housing needs assessment specifically include people experiencing domestic violence, dating violence, sexual assault, and stalking. PHAs may create a preference or a limited preference specifically for people who are referred by a partnering service organization or consortia of organizations. The PHA may not limit the source of the referral to an agency, organization, or consortia that denies its service to members of any federally protected class under fair housing laws, for example, those covered by race, color, religion, national origin, sex, disability, or familial status. For example, a PHA may not limit the source of referrals to only service providers of female victims of domestic violence, dating violence, sexual assault, or stalking. That concludes part 4 of the training. Thank you, and please stay tuned for the last part of the training.